Hi, I'm David Eddy.
And I'm Karen Rakowski. In this video, we will discuss the updated management rights test the authority applies in reviewing certain management rights challenges to arbitration awards. We call it the CFPB test. In the video description below, you can find the authority decision citation setting forth the test.
We're going to explain the elements and application of the CFPB test by explaining the arguments parties should make and arbitrators should address at arbitration, and that parties should make in arbitration appeals before the authority. We hope to help you understand your respective burdens and be able to practically apply this test in actual cases, whether you are a management representative, a union representative, or an arbitrator. We will refer to authority decisions and the Federal Service Labor Management Relations Statute, which we refer to as the statute. Links to both are included here.
Before we launch into the CFPB test, let's give a little context. The management rights provision of the statute can be found at 5 U.S.C. 7106. Section 7106 is divided into two parts. Subsection A sets forth the management rights, and subsection B generally provides exceptions to those rights. Our goal is to provide a general overview of how 7106A and 7106B interrelate in the context of appeals from arbitration awards finding violations of collective bargaining agreements. In the past, the authority applied various different management rights tests over time before issuing the CFPB decision. The decision, linked in the description, describes this history in detail, and we strongly encourage you to read it entirely. As CFPB discusses, some of the authority's pre-CFPB precedent had some drawbacks. By establishing the CFPB test, the authority attempted to fix these issues and expressed the hope that its thoroughly reasoned analysis will serve as the foundation for future decision-making, ensuring much-needed finality in this area of law.
So, let's dig into the CFPB test. You can read the four-part test in 73 FLRA 670. Before we get into the test, let's talk about a few things the test does not involve. First, the CFPB test applies only where arbitrators find violations of collective bargaining agreements, not where arbitrators find violations of law. Second, the CFPB test does not examine whether the arbitrator was wrong in determining what the collective bargaining agreement means. Instead, the test assumes the arbitrator correctly interpreted the agreement. If a party wants to challenge the arbitrator's contract interpretation, then they must separately argue that the award fails to draw its essence from the agreement. Third, the authority will not consider arguments that a party could have made but did not make to the arbitrator. With these three caveats in mind, let's turn to the 4 steps of the CFPB test. The first step asks whether the accepting party has demonstrated that the award affects a management right in Section 7106. The accepting party only needs to show that one of the 19 management rights in 7106A is affected to meet the first step of the CFPB test. An arbitrator's award can affect a management right in 2 different ways. First, the arbitrator's interpretation and application of the agreement can affect a right. And second, the arbitrator's chosen remedies can also affect the right. Let's discuss these. An arbitrator's interpretation and application of the agreement can affect management rights by either limiting how management may exercise its rights or by requiring management to do something affirmative to exercise those rights. For example, let's say an arbitrator issues an award saying the agreement prohibits management from disciplining employees. That interpretation would affect management's right to discipline by limiting management's ability to exercise that right. By contrast, let's say an arbitrator interprets the agreement as requiring management to discipline an employee. Clearly, this would affect management's right to discipline by requiring management to affirmatively exercise that right. An arbitrator's remedies can also affect management rights. For example, let's say an arbitrator directs management to either rescind or impose discipline on an employee. These remedies would affect management's right to discipline regardless of what the arbitrator said the agreement requires. Arbitration awards often affect management rights in both ways. Let's say an arbitrator interprets your agreement to prohibit management from disciplining an employee and, as a remedy, directs management to rescind that employee's discipline. In this case, both the interpretation and application of the agreement and the remedy would affect management rights. If the accepting party does not show the award affects a management right in either way, then the authority will end the CFPB analysis at step 1 and deny the management rights exception. However, if the accepting party shows that either the arbitrator's interpretation and application of the agreement or the remedy affects management rights, then the authority will move on to step 2 of the CFPB test.
Step 2 asks whether the arbitrator correctly found or the opposing party demonstrates that the contract provision, as the arbitrator interpreted and applied it, is enforceable under 7106B of the statute. Note that if the arbitrator did not address this issue, then the burden is on the opposing party to raise and prove it, unlike the first step of the CFPB test, which put the burden on the accepting party. So how can you assess whether the contract provision, as interpreted and applied, is enforceable under 7106B? You look to the authority's case law and established standards discussing the various parts of 7106B. 7106B generally concerns exceptions to management rights and has 3 parts. Subsection 1 addresses what we call permissive matters, matters agencies may, but are not required to, bargain over under the statute. However, if those matters end up in your agreement, then arbitrators may enforce them. This subsection encompasses 2 broad categories, involving numbers, types, and grades of employees, and their methods of performing work. You can find out more about what these matters involve by reading the authority's decisions. Subsection 2 concerns the procedures that management will observe in exercising their management rights. These are matters management must bargain over, which are fully enforceable in arbitration. Again, you can find out more on these types of matters by looking to authority precedent. Subsection 3 concerns appropriate arrangements for employees adversely affected by the exercise of management rights. Like procedures under 7106B2, these are matters management must bargain over, which are also fully enforceable in arbitration. To determine whether something involves an appropriate arrangement, you should look to 21 FLRA 24 at page 31, known as the KANG test, and its excessive interference requirement, as well as other decisions applying the KANG test. There is one caveat regarding KANG, however. In the negotiability context, the authority requires the party making a 7106B3 argument to demonstrate that the bargaining proposal or contract provision is sufficiently tailored to compensate or benefit employees suffering adverse effects attributable to the exercise of management rights. Under CFPB, the authority presumes the contract provision is tailored. However, a party may argue that the presumption should be rebutted. If the arbitrator did not correctly find, or the opposing party does not demonstrate that the provision falls within any of those subsections, B1, B2, or B3, then the authority will end the analysis at step 2 and set aside the relevant part of the award. However, if the arbitrator did correctly find, or the opposing party does demonstrate that the provision falls within any of 7106B's subsections, then the authority moves on to step 3. Please note that the arbitrator or the opposing party does not need to demonstrate that all 3 parts of 7106B apply. 1 is enough.
Moving on, step 3 of the CFPB test asks whether the accepting party challenges the remedy separate and apart from the arbitrator's finding of a contract violation. We just discussed that either an arbitrator's interpretation and application of an agreement or the remedies can affect management rights. If the accepting party does not challenge the arbitrator's remedy separate and apart from a contract violation finding, then the authority will end the CFPB test at step 3 and deny the management rights exception. However, if the accepting party does separately challenge the arbitrator's remedy, then we move to step 4.
Step 4 asks whether the accepting party demonstrates that the remedy fails to reasonably correlate to the enforced contract provision as the arbitrator interpreted and applied it. For example, let's say an arbitrator interprets your agreement as requiring an agency to have just cause to discipline employees and finds the agency violated the agreement by disciplining an employee without just cause. And let's say that as a remedy, the arbitrator sets aside the employee's discipline. This remedy would reasonably correlate to the contract violation. But let's say instead of setting aside the employee's discipline, the arbitrator directs the agency to promote the employee. This remedy would not reasonably correlate to a contract provision requiring just cause for discipline. So for step 4, we ask, Does the accepting party demonstrate that the remedy fails to reasonably correlate to the enforced provision? If no, then the remedy will stand and the authority will deny the management rights exception. If yes, then the authority will set aside the remedy. What happens next depends on whether the remedy the authority set aside is the sole remedy for the contract violation. If it is, then, absent unusual circumstances, the authority will remand the case to the arbitrator to come up with a different remedy to avoid letting the contract violation go unremedied. However, if the arbitrator awarded other remedies for the contract violation and the authority has not set aside those remedies, then the authority will not remand.
To sum it all up, the four-step CFPB test asks, first, does the accepting party show that the arbitrator's interpretation and application of the agreement and/or the awarded remedy affect management's rights? If no, then we deny the management rights exception. If yes, we move to step 2, where we ask, did the arbitrator correctly find, or does the opposing party show, that the contract provision, as interpreted and applied by the arbitrator, is enforceable under 7106B of the statute? If no, then we set aside the challenged part of the arbitration award. If yes, then we move to step 3. In step 3, we ask, does the accepting party challenge the remedy separate and apart from the underlying contract violation? If no, we end the analysis and deny the management rights exception. If yes, on to step 4. Finally, in step 4, we ask, does the accepting party demonstrate that the remedy fails to reasonably correlate to the enforced provision as the arbitrator interpreted and applied it? If no, then we deny the management rights exception. If yes, then we set aside the remedy. And if it's the sole remedy for the contract violation, we may remand the case so the arbitrator can provide a different remedy. The authority may not apply all of these steps in every case. For example, if it is clear that the contract provision is enforceable under 7106B, then the authority may skip step 1 and go straight to step 2. What the authority does will depend on the particular arguments and circumstances presented in each case. As the authority issues decisions applying the CFPB test, parties will get a greater understanding of how the test applies. We recommend parties read those decisions and the CFPB decision itself. Some tips for practitioners. Think about this test when litigating cases at arbitration. As we said earlier, the authority will not consider any management rights arguments you could have raised but didn't raise at arbitration. So make the arguments there.
Understand your burdens. If you're an agency representative, think about whether the union's or arbitrator's interpretation of the contract or any requested or awarded remedies would conflict with management rights. And if you think they would, argue that. If you're a union representative, respond to the agency's management rights claims and argue why the contract interpretation you're proposing meets the requirements of 7106B and why your requested remedies reasonably correlate to the contract interpretation you're proposing.
In looking at these issues, consider authority standards and precedents across case types. Often parties to arbitration only look at how management rights apply in arbitration decisions. Don't limit your research or your arguments that way. There is a wealth of precedent elsewhere, such as negotiability and unfair labor practice case law, discussing management rights and the exceptions to those rights. Look at those cases and apply them to your particular circumstances.
We hope you found this video useful. The description includes links to the CFPB decision, flowchart, and other resources to assist in developing your case before arbitrators and the authority, as well as a survey to provide feedback on this training.